Welcome, everyone. We have a different setup for today. For those of you who regularly come to the CLX webinars, we have a special setup and a special guest today. We have Dr. Ian Fry with us, who's, of course, the UN Rapporteur on Climate and Human Rights with us. And the setup today is hybrid. We have some colleagues here at the NYU School of Law. And we took the opportunity of having Ian around to do an in-person roundtable, but as usual, most participants connect from around the world. And I'll just say, for those of you who have not participated in CLX's webinars, that CLX is a global collaborative that conducts research, advocacy, and brings together a community of practice of scholars and activists who work actively on climate litigation. We convene a monthly webinar where we discuss cutting-edge findings from science, new developments in law, new cases and rulings. The most recent webinar was on Flood versus Montana. We had an interview with one of the key lawyers in that case, and today we thought we would organize this session around the latest report of the rapporteurship that Dr. Ian Fry leads. Dr. Fry is an expert in international law and policy. He worked for the Tuvalu government for over 21 years, serving as their ambassador for climate change and environment from 2015 until 2019. He's a professor at the Australian National University, and he serves as the Pacific Regional Representative to the UN for the International Council on Environmental Law. He also coordinates the least developed countries on matters relating to carbon markets and is currently on the bureau of the UNFCCC. In March 2022, the Human Rights Council appointed Dr. Fry to be the first special rapporteur on human rights and climate change. As special rapporteur, Dr. Fry has issued reports on the rights of persons displaced by climate change and the human rights implications of failing to mitigate greenhouse gas emissions. Yesterday, Dr. Fry delivered his latest report to the UN General Assembly on climate change legislation, litigation, and intergenerational justice. We will be discussing this report today, and for those of you who have not had a chance to read it, I highly recommend that it's incredibly helpful for those of us conducting research and practice in the climate litigation space. A quick note before we begin. For those of you on Zoom, please submit any questions you have in the Q&A box at the bottom of your screen. We will leave ample time for questions from the audience. As those of you who have come to the more recent installments of the webinar, we're conducting the webinar not as a presentation, not even as an interview, but more of a conversation. So I'll offer some prompts. By the way, I should introduce myself. My name is César Rodríguez-Garavito. I'm a professor of clinical law here at the New York University School of Law, and I lead the Climate Law Accelerator. I'm going to offer some prompts for Dr. Fry to come in and comment on his report, but really this is supposed to be more of a conversation. At minute 40, we will definitely stop the internal round of prompts and responses here, and then open it up to all of you in the audience. So, Dr. Fry, thanks for making time to be with us today. For those who haven't had a chance to read the report, could you briefly summarize the key findings?
Well, thank you very much for inviting me, and it's a real pleasure to be here. So I sort of divided my report into I guess, 4 thematic issues. One was looking at environmental rights defenders and the current state of play with that, and I'll go into that in more detail. I did a review of climate change legislation to see what countries were including within their legislation, how much they picked up sort of climate change issues and human rights issues within that. I looked at the sort of current climate change litigation. It was a sort of overview of that, and really trying to find where the litigation was heading and what are some of the barriers to people getting access to litigation, and that was a sort of a critical aspect of it. And the sort of 4th thematic issue was looking at intergenerational justice. How do we ascribe rights for future generations into law? So they were the sort of four issues I was looking at.
Of course, I'm tempted to ask you to say more about each of them, but I'm going to start with a high-level question about the role that you see for climate litigation in global governance, in climate governance, because you have a lot of experience in negotiations. And back in the day, for those of us who started working on these issues about, in the mid-2010s, there was this, it's not a divide, a certain kind of certainly a distinction between those who do the negotiations and those who do litigation. So coming from climate negotiations and now going into this report, studying and doing the overview of climate litigation, how do you see those two different approaches playing out in climate governance?
Well, it's a critical area. I think, the negotiation process is often very slow to get outcomes, and we're seeing that currently on the loss and damage front, where we're negotiating a loss and damage fund. And so that, litigation plays a critical role, and particularly because it's now focusing on the private sector and corporate responsibility. And I think that's the area where, there'll be a lot of advancement in making corporations accountable for their actions as far as their investments in fossil fuels, and what they're doing as far as, taking action on climate change. And there are issues around greenwashing, as we're seeing it within the sort of reporting area as well. So I see, litigation as a sort of a critical area.
And then going deeper into litigation, in the report, you usually lay out some of the trends in this field. What do you see as the most promising trends in litigation, climate litigation?
Well, I mean, a lot of the litigation started off with sort of, against countries and their lack of action on climate change, and that was quite useful. The agenda case and those were very important in driving, national obligations. But we're now starting to get into corporate responsibility, and in particular the responsibility of board directors. And I think that's the real tension point, that we're going to see, if there's personal liability for board directors, then things might change a bit. The business has sort of flown under the radar screen for a lot of litigation, and I think it's mainly been focused on actions by governments, but now we're starting to pinpoint corporations, and in particular, board members, and that has an influence on share prices. And there's been some studies looking at the impacts of litigation against companies and their share price, and shareholder behavior. So I think they're very useful points of entry into it and where it's heading. And there's been some pushbacks on that, and I think there was a recent Greenpeace and Shell case which was thrown out of court. The judge said, it's not a responsibility of board members to be totally responsible for the actions of their companies, which is a bizarre response, I guess. And I'm sure this will be tested more.
Following up on that point, as you know, we curate a database of rights-based climate litigation here at Climate at CLX at NYU, and that finding kind of is consistent across the board, across the years, but it's starting to change, as you note in your report. So it used to be that corporate targets would make up around 8% of total climate litigation. Now it's closer to 16%. So it's twice as large, although the starting point was not that big. And we now have the Shell case, the Holcim case, the RWE case. And now, as you also work on, and we all start to pay more attention to loss and damage, you wrote a previous report where you highlighted this kind of gaping hole in climate governance. How do you see climate litigation contributing to filling in that gap, filling the gap of loss and damage?
Yeah, it's an interesting question, I guess, and it gets around this issue of reparations, I guess, and are we moving into a sort of realm of reparations in litigation? And I think this is certainly an area that warrants further considerations, and we're looking at this. I mean, this is the reason why we're getting pushback on the loss and damage fund. The US negotiators are very nervous about liability and compensation. So they're trying to sort of stall outcomes on funding for the loss and damage fund, but I really think there are real opportunities there. If we saw the Billy case of Torres Strait Islanders that went before the Human Rights Committee, that was quite important to say Australia had not done enough, and should pay for adaptation responses. So I think we're starting to move into that area of reparations, because I honestly think we're not going to get the sort of funding requirements that are necessary to deal with the current impacts of climate change. And that was the sort of point of my report last year, the UN General Assembly. The orders of magnitude of the costs that countries are having to deal with as far as climate change are enormous. I was in Pakistan earlier this year, and they basically, suffered floods in 22, and it was estimated that cost them about $3.5 billion worth in damage. And so these are the costs, and it's predominantly developing countries are having to pay those costs. We're seeing issues around climate change migrants and the costs that countries have to pay to host those migrants. And there's a big so-called refugee camp in Kenya at the moment from Somalians who have escaped a very long drought, and so they're picking up those costs. And so there's a lot of costs associated with climate change impacts at the moment, and so I think this is an area that's going to advance quite significantly.
Mm-hmm. One of the things that I found most interesting about the report is the attention you pay to procedural hurdles, because many of the most promising lawsuits have foundered kind of on procedural basis, be it standing issues or evidence or issues having to do with proving that the remedies that were asked for were warranted, and importantly, the procedural answers or the court's answers to those procedural questions have evolved even within the last 5 years or so. So courts and litigants have come up with answers to some of those questions. So how do you see that evolution? What do you see as the most formidable kind of outstanding obstacles on the procedural side of things for climate litigation?
Well, obviously cost is a sort of major issue, particularly in a country like the US, I guess, of litigating these sorts of issues. So, for people, who are impacted by climate change are often poor communities, so that, that being able to take cases is a real challenge for that, and obviously there are public interest litigation firms will do some of that, but the costs and warding of costs against people is often a challenge, and so that's an issue. The issue of sort of burden of proof and causal link has always been an issue with climate change litigation, but I think that barrier is breaking down. I really think we're the science is a lot more precise now. And connect, the source to the cause. When I was working for the Tuvalu government back in 2003, we had a tort lawyer come from the States to want to run, get Tuvalu to run a case against a company here in the US, and the issues around causal links were just too broad, and not willing to take them on. One of the interesting ones, doing a survey across the globe is, the level of knowledge of the judiciary about what is climate change, what is climate change science, and what are the connections to human rights. And there's a broad spectrum of understanding of the judiciary around these issues. And so that's seriously a barrier. And that's one of the recommendations I put into this report. One of the first things I did as Special Rapporteur was to participate in a workshop being run in the Pacific by UNEP and IUCN for judges in the Pacific to understand what climate change is and, you know, what are the human rights implications of that. And you know, I think that really helped. And so, you know, I'm suggesting that maybe we need some guidebooks just to help the judiciary understand those issues. And that I think that's quite interesting. Of course, you know, fear of counterclaims is a really real concern, particularly, you know, slap suits and things like that is a big issue. And of course, you know, talking to Indigenous peoples and poorer communities, you know, access to courts because of language difficulties is a real problem. And, you know, understanding legal language, or, you know, even, you know, being able to speak the language of the sort of the colonial language of the courts is a real challenge. So, you know, that's been a real serious problem for Indigenous peoples, I guess. So they're some of the sort of barriers, I guess, around that. But, you know, some of them are breaking down. You know, there are also age barriers as well. You know, there's some courts don't allow youth to be, you know, appear before court. And of course, there's the issue of, you know, that people have to show a direct interest in the issue. In some cases, and in some jurisdictions, you have to show direct interest, and that test of direct interest is often difficult to pass, particularly for, you know, civil society organizations.
Now, some litigants have chosen to go to domestic courts, and increasingly some organizations are going to regional international courts. And there's been an active debate, even in one of the webinars that we had a couple of years ago, about the wisdom of going straight to regional courts or international courts without exhausting domestic remedies, not only for procedural reasons, because of course that creates a barrier that, for example, made the claim before the UN Committee on the Rights of the Child kind of ultimately fail, but also because of the potential kind of competition between organizations that are domestically focused and organizations that have access to regional courts. And this has played out in the context, as you probably know, of the cases that have been brought before the European Court of Human Rights. And the litigants who have spearheaded those efforts say, well, no single country will be able to deal with climate change. So by definition, we need to aggregate those interests and go directly to regional courts, even to universal jurisdiction. And then you have those who say, well, there's a patient way up, and there's a way in which each country deals with its own issues, and they have and its own procedural and substantive legal issues. What's your view on that conversation?
Well, you know, it's a matter of where are you going to get an outcome that suits your interests, I guess. And I think people have to think whether the legislation within a country is enough to deliver an outcome that will deliver results, or you know, it's better to get a decision from a higher court, I guess. And I guess there are sort of levels of frustration with, you know, domestic measures, and it's a challenging issue because it is climate change, and where the sources of the pollution are diverse. It's very hard to just say within a domestic jurisdiction that, you know, you can deal with that. So I think there are opportunities for sort of more regional and international, you know, courts to take on these issues.
And on that note, as you know, a lot of the actors in this field, including ourselves, are very busy finishing submissions to the Inter-American Court of Human Rights, and in the future the ICJ. And what would you hope would come out of those processes and all the effort that's being put, not only, of course, by courts themselves, but also by civil society and everyone that's kind of putting their hopes in this process?
Yeah, I mean, to be honest, I was very skeptical about the ICJ, seeking a view from the ICJ advisory opinion. To start off with, I don't think the question was, it was too broad, and, you know, could be easily answered, you know, and would not deliver anything new. I think there was some work to sort of, you know, tighten the questions to, you know, to advance jurisprudence at the international level around, you know, aspects of responsibility on climate change. So I think that has changed, and I guess, you know, hopefully the ICJ will deliver some clear signals of, you know, transboundary harm issues, you know, responsibilities of future generations. You know, I think they're critical signals that we need to get out of the ICJ.
Speaking of which, and I promised to stop, the thing is that you're very concise in your answers, so I have to come up with more questions.
I'm sorry.
Which is good. Which is a good thing. You're well trained. But we've had different types of speakers here, so I usually come up with 3 questions, and that tends to be enough. But moving on more seriously to the part of your report when you write about intergenerational justice, and you say, well, it's not only equity but justice. Could you explain that conceptual move?
I'll take longer. Well, the whole concept of intergenerational equity has been around for a long time. It goes right back to the Stockholm Declaration 50 years ago, and so that, you know, we've had this sort of concept around, you know, in sort of soft law agreements for a long time, but it, you know, it hasn't really translated into real legal action, I guess. And so you know, I was trying to explore where intergenerational justice has surfaced, you know, and as a right for future generations, and where is that going to, you know, where is that right going to be ascribed? And you know, we looked at some you know, some constitutions, you know, inscribe that right, you know, in some of the countries. But it's very ad hoc, and there's no real consideration that in international law in any substantial way. So you know, as you know, a number of jurists have put together this Maastricht Principles on Human Rights and Intergenerational Justice, and I think this is a good signal of the things that need to be incorporated within that. I think it's too long, you know, it needs to be, you know, narrowed down a bit, I guess, but nevertheless, it's a useful way forward. And so in my report yesterday to the General Assembly, I suggested that maybe there needs to be UN General Assembly resolution around this issue of intergenerational justice, you know, and for countries to look at the Maastricht Principles and see whether they can develop a resolution around that to sort of, you know, advance this issue of intergenerational justice, like we saw with the UN, you know, resolution on the right to a clean, healthy, and sustainable environment. So, you know, I think that there are opportunities there.
And finally, so we're going to start transitioning towards the Q&A. So for those of you online, please do drop those questions in the chat. And for those of you here in the room, I'll give you a chance. After all, you battled the rain here to get here. So this audience is made up mostly of climate litigation researchers and practitioners. If you were to send one message to climate litigation practitioners, especially about the gaps that you identify, things that are not being done that you wish more people were doing, what would that be?
Good question. Well, I mean, the problem is a lot of the world is not represented by climate change litigation, and that there's a big gap, particularly in developing countries. It is expanding, but there is a big gap there, and so whatever support can be provided for developing countries to take on litigation, I think that would be extremely helpful. And I think that this sort of big question of how do we take on corporations is the real area we really need to work on and advance that issue. So, working on that area, I think is critical.
I can't resist asking a short follow-up question. Just a couple of days ago in my class here at the law school, we had David Boyd, and we discussed it. We had supported here at CLX a case before the East African Court of Justice against the ECO pipeline. And we submitted amicus with natural justice, also worked with Rikiri on evidence on the projected emissions of that pipeline. And David was a bit skeptical about that type of litigation, not because he's not a champion of climate litigation, as you know, he's done some of that and he supported a lot of that. But he said, well, if I have to choose targets, I wouldn't go against global South countries. Why would you litigate or focus on stopping a pipeline in Uganda and Tanzania when the US and China and other European countries are the leading oil producers? You represented Tuvalu for a long time, so you do see the world from that angle as well. So what's your view about priorities in climate litigation against government?
Yeah, well, I mean, there are a number of aspects to this, and what we're seeing at the moment is, developed country corporations operating in developing countries. So I think there are opportunities to take on those companies. I was just recently in Bangkok, and there was a lot of discussions around critical minerals, and there's a huge push to access the sort of critical minerals for the electronic vehicles and things like that, and we're seeing huge competition between the US and China to get access to those minerals, and there are lots of human rights abuses as a consequence of that, and we're seeing that happening in Indonesia and the Philippines. I'm going to the Philippines next month to look at that. And a lot of those corporations are multinational corporations, Canadian, Australian companies doing that. And so they should be the targets, not necessarily what's happening in the countries themselves, but the target should be these sort of big corporations that are undertaking that sort of work. So I think that there are areas there. Of course, the real challenge is, there are a lot of Chinese companies operating in these under the sort of Belt and Road Initiative, and being able to, tackle them from a litigation perspective is a new and interesting area of challenge, I think. And, I hope that be done. And on the other side of the coin, I presume David, because he gave his report on, investor-state dispute settlements. This is a huge area of work that needs to be worked on, to pull apart that whole system, because, developing countries are paying out enormous sums of money under these dispute settlement arrangements that they shouldn't have to. So that's just another area of work that needs to be done.
Thanks, Ian. Okay, so we can take questions now.
So we have some questions up there, and we also have a room of some questions in the room as well.
Okay, because this is a hybrid event, I haven't had a chance to read those questions as usual. So I'm gonna go first with a couple from the room, and then we'll go to a couple that will alternate. Okay. So Nora, if you could speak into the owl here.
Yes.
Look at his eyes.
Okay, thank you. Nora Market, University of Münster in Germany, and currently scholar in residence at the Center for Human Rights and Public Justice. I have a ton of questions. I'll try and focus on two aspects that you've mentioned. One is climate migration, and you've mentioned the enormous cost that states are bearing who are housing migrants. And you mentioned this, if I understood you correctly, in the context of reparations or sort of compensation of some sort. And I'm wondering whether this is getting into dangerous territory, because if we sort of start understanding the production of migrants as maybe an internationally wrongful act of some sort, where you owe compensation for the housing of the migrants, then you transform obligations, for example, under the Convention Against Torture or the Geneva Convention for the Protection of the Status of Refugees into sort of actionable cost. And I think that might be a dangerous development. So I just wonder what your opinion is on that. If I may connect that to one small second question, on another form of outsourcing of costs, namely the outsourcing of the cost of the sort of the transformation that we're seeing in the developed countries right now. You mentioned mining and human rights violations in that respect. We're talking about sort of more electric cars and energy and so on, and more devices. All of that is still based on very sort of original extraction energy or sort of resources. Do you think it's important to sort of focus litigation efforts, for example, in parallel, or also regulation efforts on these sort of forms of violations that are happening as an effect of that type of transformation? Or do you think there's a risk also in undermining those ongoing efforts by also saying like, look, what you guys are doing is like better on this front, but horrible on that front?
Yeah, well, they're challenging issues. I mean, the issue of climate change displacement, I reported that on that issue in the last Human Rights Council. And one of the critical issues is that people who are displaced across international borders as a consequence of climate change are not defined as refugees under the Refugee Convention, and they fall through the cracks as far as legal protection is concerned. You know, there are soft law agreements to deal with that, and you know, there are some human rights provisions, but it's not very strong. And you know, I made the recommendation that maybe we need to develop an optional protocol under the Refugee Convention to define climate change refugees to give them proper protection. I was just recently in Honduras, and I went to various parts of the country, and every region of the country I went to, where there were people suffering from droughts, from floods, sea level rise and storm surges, hurricanes. They'd lost members of their family or community to people who just left. You know, it was unviable for them to stay. It's unviable for them to migrate to the capital. So they've migrated out of the country. And so that, you know, these people are, you know, in a desperate situation. So, but there are costs for countries who have to, you know, pick up these people and you know, provide them with services. So should we be looking at legal obligations to support those countries that are having to look after those people, and so that's sort of one of the issues. As far as the sort of you know, the issues around mining and human rights issues around that, it's all part of this corporate responsibility issue, I guess, is that if we look at the value chain of products, that, you know, there should be some sort of assessment of what are the human rights violations that are occurring in the sourcing of these minerals. I mean, it's useful to be using these minerals, you know, to address climate change, but we shouldn't forget that there are human rights you know, violations occurring to do that. And you know, at the moment there is huge economic pressure to just source these minerals without any consideration of the human rights implications, and that's a real issue. The other issue, sort of following on from that, is what I'm, you know, we're looking at one of my other reports, is this whole issue of just transition. You know, how to protect the rights of people who are maybe left behind as we transition to, you know, renewable energy economies. And this is a big issue, particularly in developing countries, around, you know, protecting people who may be left behind. You know, I was just in Thailand, and there's a big industry in car manufacturing in Thailand, car, you know, repair industry, whatever. And these are for internal combustion engines. So there's a whole industry of people built around building and maintaining internal combustion engines. And if we're moving away from that, then we have to think, you know, can we provide appropriate measures to deal with that? The just transition issue is, you know, causing a lot of tension, particularly in Vietnam at the moment. You know, there's international finance, there's support Vietnam in just transition measures, and people, environmental human rights defenders who are expressing concern about that are being put in jail at the moment, and under sort of so-called tax evasion laws, which is obviously an issue. So, there's no easy answer to these issues, but I think we have to look through the sort of value chain, particularly if there are sort of human rights implications in each of these sort of actions.
So I'm gonna go to one of the questions on online that was posted online, and some of the questions were already addressed in either the responses to some of my questions or in what Ian just said. But I'm going to start with a more generic one. So Laurel Fletcher is asking about the relationship between climate governance and international human rights. She says, your mandate was established only recently. Human rights has had an ambivalent relationship to environmental issues for many reasons. In light of this, can you talk about what has changed to bring about your mandate? Who was behind it as a champion? Looking ahead, what are the largest challenges to the international human rights system to address climate change?
Yeah, thank you. Well, it was a core group of countries who kept on bringing resolutions in the Human Rights Council on climate change and human rights. It was the Philippines, Bangladesh, and some island countries, I think Bahamas. So there was a core group of countries who kept on bringing this, but they never made the step towards, resolving to create a special rapporteur's position until 2021, where, Marshall Islands basically took over that sort of group and formed a sort of core group of their own with other island countries, Fiji and some of the island countries said, we need a special rapporteur on this. And so they pushed for that. But so that's the issue, and it's right that there is this sort of disconnect between climate change and human rights issues, and it's it's part of what I'm trying to do is to bridge that connection, and there are issues. I attend climate change COPs, and where there's a small group of countries that sort of friends of human rights and climate change that sort of trying to make those connections. And to bring human rights language within decisions. But there's also countries who are pushing back on that. And we noticed that in the last COP, there were some African countries that were pushing back on human rights issues. Partially that's an issue because they saw human rights concerns equating with gay rights concerns. So there was sort of perception issues around that were blocking it. And of course, there are pushbacks to saying human rights is a sort of northern construct. You're telling us how to develop under a human rights lens. We don't think that's appropriate. So, but for many countries, and particularly small island states who picked up this issue in particular, it's human rights are indivisible with the impacts of climate change. Right to life, food, shelter, all those basic human rights are being impacted by climate change, and so there's a strong link to pursue that issue and to make those links. And I noticed the difference here. When I report to Human Rights Council, obviously there's a sort of human rights bubble in Geneva, and when I come to New York, it's not so strong. Making that connection of human rights issues, with country representatives is not so strong. Obviously, representatives here have much broader agendas to deal with.
We'll come back to the room here, Jacob.
Yeah. So thank you very much for being here, and so you've spoken some about the interaction between climate change litigation and negotiations. And in your report, you write about transboundary harms and sort of cross-country litigation. And I'm wondering if you could speak a little bit more about as that trend continues to develop, how you think that might interact with the negotiations that are happening in the UNFCCC. and whether or not it's going to, like, are there potential issues that might flow out of, litigation that's happening, like the RWE case in Germany or other similar cases that either cross the north-south divide or, other international borders.
Yeah, well, I guess there's a growing frustration that, that we're not making the progress that we promised to do under the Paris Agreement, and sort of staying below 1.5 degrees Celsius. And the negotiation process itself is quite slow. And, the commitment by countries to take action is not as strong as what we'd like. And this will come out in the discussions at the next COP under the global stocktake. So we're seeing a reluctance of countries to take on stronger targets, and that came out of the sort of the recent climate discussions here in New York. That it was more focused around finance, and so there's a sort of deal structure there. That the countries who promised the 100 billion for climate finance hasn't been delivered. So the developing countries are saying, why should we be doing more if you haven't delivered the finance? So there's those sort of games played out in the climate change negotiations, and that's been played out particularly around the loss and damage issue. So, the issue of litigation is, are there leverage points with litigation to push countries to do more? And I think that's where there are real opportunities to push countries and companies to do more, because we're clearly not doing enough. So whatever action we can to sort of push the agenda to force much stronger action on climate change, we should be doing it.
So if I could just clarify, are you saying that litigation may sort of force or help global South countries leverage their position in negotiations? Is that something that you think might be happening?
Yeah, I think so. From a vulnerable country's perspective, I think there are opportunities there, and I think that's why, Vanuatu brought the case on the ICJ, realizing there's not being enough done. The negotiations are too slow. They're not making commitments. Let's get some higher court decisions on these issues. So yeah, there's certainly, from a vulnerable country's perspective, a clear interest in pursuing this sort of litigation area as well.
Mm-hmm. So we'll go to the online audience. There are a number of questions about corporate litigation. So people really do want you to go deeper into that part of your report. And maybe I'll start with a question that Christine Casper asks about something specific about slabs. Beyond, which is something that, of course, is hanging over a lot of people's heads and as they litigate against a corporation. So she asks, beyond the European Commission's draft directive, what other steps should be taken to deter slabs brought by corporations seeking to silence climate advocacy inside and outside courts? Of course.
Well, I have to put a caveat on everything I'm saying here, is that as a special rapporteur, I have to deal with all issues connected to human rights and climate change, and I can't be an absolute expert on everything. So I haven't followed closely, the current sort of discussions around slab suits. That's to be honest. Clearly it's a major concern. I know the EU's trying to deal with that, and hopefully other countries will pick up that initiative. That the EU are trying to do, and to try and knock out slab suits, and that there are some developing countries working on that area as well. So. But I can't give a more definitive answer than that, I guess.
A related, somehow related question that also comes out from some of the ones that were posted here has to do with climate defenders, which do have a space in your report. The UN Rapporteur on the rights of human rights defenders came out very strongly against the persecution of youth defenders in Uganda, precisely for the activism against the pipeline that I mentioned earlier. and we see new anti-protest legislation creeping up everywhere from the UK to many places in Europe. What's your view on that trend, and how do you deal with it, and how's your rapporteurship dealt with it?
Yeah, well, this is a disturbing trend. That there seems to be a crackdown on these environmental human rights defenders, and it's a global trend, and it's very disturbing. And I presume, you know, there's corporate pressure coming to push for that. And as I was saying, you know, in Vietnam, there's you know, people being put in jail against some of the government's measures on just transition. I've written an allegation letter to the UK government about the jailing of protesters, that, you know, hanging a banner off a bridge, you know, put people in jail for 4 years. I mean, that's just a, you know, total overreaction, you know, for you know, a basic protest and the basic right to protest, you know, which is a, you know, a basic human right. So that there is a disturbing trend happening across the globe. While I was in Honduras, there were for the 10 days I was in Honduras, there were 3 human rights activists attacked, one of them killed. So, you know, there's some very brave people out there. And of course, you know, Indigenous peoples are the most number of people who are being attacked and killed for trying to protect their lands. So it is a growing trend, and I've also, you know, written allegation letters against the Australian government and Woodside Petroleum about the expansion of a gas facility affecting First Nations countries' land there. So, you know, these are growing issues, and countries within their own legislation aren't, you know, dealing with this adequately. And in my report last year, I suggested maybe we should be looking at some sort of international tribunal to you know, litigate against people who harass and kill these human rights defenders. I just don't think there's enough domestic action to deal with this, and because it's so widespread, that we need some sort of international tribunal to look at that.
Thank you. We'll go back to the room here. Adam?
I was wondering if you could talk more about the role of science in climate litigation. I know you mentioned it from when you started dealing with some of the tort cases early on in Tulu. The science has developed a lot. Can you talk about how that fits into climate litigation, and also access to science in different parts of the world? And if that's equal, I know you talked about access to litigation, but is there enough science to support lawsuits like equally among different regions?
Well, I suspect there is and there isn't. I mean, the reports of the Intergovernmental Panel are getting more precise, and you know, getting more location specific. And you know, we can see that, and so I think the science is advancing significantly around this issue, and therefore it's a very useful tool. But the understanding of that science, and you know, for litigants to understand that science and bring forward that science, is still a challenge. And so you know, there needs to be opportunities. There's been workshops in the Pacific, you know, to make that link, you know, to bring the science forward into those issues. But in other parts of the world, it's not well developed, I think, and there's certainly a lot of room for, you know, bringing the climate science into courts, and, you know, getting people to understand the climate science more.
Thank you so much for
Just speak up so that people can.
yes. I think so. My question has to deal with like the issue of intersectionality, which you're touching on, and you know, with like a lot of the issues that you mentioned with climate migration and just like impacts on Indigenous populations, as well as, you know, women and LGBTQ plus individuals. You know, the harms are, you know, a lot greater, and the discrimination is a lot huger for the impacts of environmental harm. And so I was just curious, like the best way that states should be dealing with this, or like what your view was in ensuring the greater protection for these more vulnerable groups when they are facing these environmental challenges and, you know, migration issues as well.
Yeah, well, it's a good question, and clearly there are, you know, significant intersectional issues around race, you know, gender, age, you know, youth, old people, class. There are all sorts of intersectional issues that, you know, make some people more vulnerable to the impacts of climate change, and certainly gender identity is part of that. And I've been, you know, working with the special rapporteur on sexual orientation and gender identity to look at those issues, in particular the specific concerns of LGBTIQ plus community and climate change, and what sort of responses are there. Of course, you know, they're dealing with those intersectional issues is a challenge because of historical issues, you know. And I met with some African-American women from Louisiana last year at the climate change COP, you know, and there are certainly, you know, racial issues connected to climate change vulnerability that are very serious. And you know, meeting with Indigenous peoples at the COP, you know, I could spend all my time as special rapporteur dealing with Indigenous people's issues and climate change. So pulling those sorts of issues together, you know, and getting greater responsibility for dealing with those issues by governments is a challenge because of, you know, these inherent biases. And so I in my report that I gave yesterday, I provided some principles for climate change legislation. And so that the idea is some key steps that could be applied for countries to incorporate some of these issues within their climate change legislation. And hopefully countries will start thinking about some of those issues. But those issues are a real challenge, and it comes up all the time in what I'm doing. You know, that even with new technologies, for instance, Sami people have come to me about you know, the development of wind turbines on their territory without free, prior, informed consent, and that's affecting their reindeer herds because the wind turbines scare away the reindeers, the access roads divide up their territories, etc. So there's all sorts of issues, you know, making that connection. And you know, but clearly we also have to think these people are not just victims, that they're drivers of innovation, and we need to open up the space for those people to drive outcomes, you know, as far as, and that's what I was saying in this sort of climate change legislation. You know, disadvantaged communities need to also have you know, a seat at the table and be able to provide, you know, a clear actions as far as their needs, as far as mitigation, adaptation, loss and damage, education, things like that. So, you know, there are opportunities, but of course there are significant sort of barriers to deal with that.
Since we started a bit late, we have 1 minute, 2 minutes for a final question on a more forward-looking topic. So Maria Che asks, I would like to know if by any chance intergenerational rights could have been granted as a general principle of law, or could be granted as a general principle of law in accordance with the Article 38C of ICJ statute. The Inter-American Court of Human Rights, for instance, recognized this right, but the normative status of the right is still not clearly established. So how do you see the status, legal status of what you're suggesting in your report in terms of the move from equity to justice?
Well, I think as the person has asked, you know, there's some development in this area, and hopefully, you know, the ICJ case will advance this further, and to identify, you know, the legal obligations. You know, I think you can find some, certainly in some of the, you know, human rights treaties, and, you know, in some jurisprudence, and we're seeing some of that surface, and I think we can draw on that jurisprudence to use that as a basis for getting this to become, you know, accepted either in customary international law or we push that agenda, and that's why I was suggesting this UN General Assembly resolution to try and push that agenda, you know, further, you know, so that it becomes customary international law.
Thank you so much, Ian. We really appreciate the time, of course, the report, which I do believe is going to be very helpful for both researchers and practitioners. And there are many more nuggets there for practitioners and scholars that I would suggest people find by themselves in reading the report. That really we covered only the basics here. There's a lot, and I'm glad that you mentioned this list of suggestions for climate legislation. That's going to be very helpful for legislators, for governments in general that are coming up with new pieces of legislation. But I'm hoping that this will only start the conversation with your mandate, and also that the CLX community of practice will take advantage of this new report. So thanks everyone for attending today, for those of you who are here in person and for those of you who connected online, and stay tuned for the next webinar, which we'll be announcing soon.